I'll talk now about some other uses of these domestic asset protection trusts other than just pure asset protection. One is to use this actually as an estate planning tool. You can transfer assets into a DAPT trust, and as I mentioned, by holding veto powers and powers to redirect where the assets go, you can avoid that being a completed gift. But let's say the client wants to actually remove these assets that he puts into this DAPT trust, have them removed from his taxable estate, and therefore make it a completed gift. And filing a gift tax return and all the things that go along with that in your standard type of estate planning maneuver, you can design a DAPT trust to be a completed gift trust. And that way you get all the benefits of regular estate planning goals, and that's removing the assets outside the settlor's taxable estate. All the appreciation that grows in that trust going forward are all outside the settlor's taxable estate. But the added benefit, though, when you use a DAPT for this purpose, is that the settlor can still be a beneficiary of this trust. So if it's designed properly, then the settlor sort of has their cake and they can eat it too, in a sense that the settlor has removed these assets from his estate out of his control, because now a trustee who, for example, could have pure discretion whether or not to distribute any money back to the settlor, and yet if someday down the road, 20, 30 years later or whatever, the client ends up being in financial straits and is in bad need of some help and support from the trustee can take that into consideration, and it sort of gives you that rainy day aspect that it is there, the trust is there for access when the time arises and the need is really there. If you try to do that in one of the non-DAPT states, the other, the 35 states that don't allow for DAPTs, just being the beneficiary of that trust alone will prevent that trust from being effective at all as far as removing those assets from the client's taxable estate. Just the fact that the client is the settlor and a beneficiary of the trust makes it so that now, as John mentioned, the self-settled trust in those non-DAPT states allow the creditors to access the same amount that the trustee could have distributed to the settlor. So if that trustee has discretionary powers to distribute any or all of the assets back to the settlor, the creditor also has access to all those assets. And then under the tax laws, which dovetail right with the asset protection laws, the tax laws say, well, if your creditors can get to those trust assets, then we're also going to tax it in the settlor's taxable estate. So in order to do these completed gift DAPTs, you need to do it in one of the DAPT states. So another common vehicle in the estate planning context that you can use a DAPT for is this concept. You've heard of the typical A-B trust approach, where husband, for example, creates at his death a marital trust, which we call the A trust, and a bypass trust or credit shelter trust, which we call the B trust. And the husband may name the surviving spouse as the beneficiary, along with the kids possibly, as the beneficiary of the bypass trust. And the tax savings there is that the settlor can put $5.43 million into this trust without paying any estate taxes, and then when the surviving spouse dies, it even bypasses her estate and never is taxed in her estate. So again, it doesn't get taxed at the second spouse's death.